Hi, my name is John Goodman. I'm an attorney licensed to practice law in the state of Colorado, and today we are talking about what are the consequences for a lease, what are the consequences for a landlord, what are the consequences for a tenant when the landlord sells the property to a new owner. As we talk about this, it's helpful to have terminology. So we will call the initial landlord the landlord who signed up the lease with the tenant, the original landlord. The original landlord sells the property to a buyer, and we will call that new landlord the new landlord. Imagine as at the time the new landlord is buying the property, the original landlord had already entered into a lease with tenant. When original landlord closes on the sale to new landlord, the initial question is new landlord still bound by the terms of the lease to the tenant? And the answer to that question, at least in Colorado and under the common law, is a decisive yes. The new landlord is bound to honor the terms of that existing lease. Why is that? Well, one of the reasons is just so that the law has a decisive resolution. The law is decisive on that topic, and people can take that into account as they purchase property. If the buyer doesn't like that result, the buyer can condition the buyer's willingness to acquire the property on the old landlord and the tenant terminating the lease. So one of the reasons the law is like that is just to be decisive. But there's also another concept in the law. We tend to think of real estate rights as a bundle of sticks. And the concept is that when a landlord enters into a lease with a tenant, the landlord is conveying some of those sticks to the tenant. The tenant has those sticks until the tenant's leasehold rights expire or until the tenant defaults, in which case those rights come back to the landlord. The concept is that the new owner, the new landlord, does not have the right to eliminate the tenant's rights in the lease. The next question is, what about the effects for the tenant? The tenant may have entered into the lease partly based on who the landlord was. And when the original landlord sells the property to new landlord, that might be a consideration for the tenant wanting to get out of the lease. Does the tenant have the ability to terminate the lease because of the transfer? And the short answer under Colorado law and also under the common law is no. The concept is that the lease obligations of the tenant, quote, run with the land, and that the new owner, the new landlord, now is deemed to have a direct relationship with the tenant, and the tenant is bound by the lease. Tenants can provide otherwise in the lease. In other words, a negotiated term of a lease could be a very flattering provision for the landlord, not in their best interest, not in the landlord's best interest, but flattering, that if the property changes hands, that the tenant has the ability to terminate the lease. That's generally not a desirable provision for the original landlord because that makes the landlord's right to receive the rent on that lease dodgier and makes the lease rights less valuable to the landlord. Ladies and gentlemen, what I've been saying is relevant and reasonably accurate for the state of Colorado. For those of you who are watching this in your state, you should engage an attorney in your state to advise you in this situation. The information that I provide is designed to be general legal information, not legal advice. For advice in a particular situation, talk to your own lawyer. And in general, remember, we live in a complicated world. Be careful out there.